All right, perfect. Well, good afternoon. Thank you guys for joining us. Today we're going to talk about alternatives to guardianship. And I know this is going to be a great presentation, and I know this is a really hot topic. So we look forward to getting into it and talking about it and answering your questions today. And before we get started, I just want to tell you who we are and what we do, and then we'll get over to Ms. Colleen. I'm Megan Sanders, and I'm the Training and Evaluation Specialist for Partners Resource Network. Joining me today is the Director of Statewide Services, Mrs. Christina Henning. So she will be on with us today. Partners Resource Network is the nonprofit agency that operates the statewide networks of parent training and information centers in Texas. So you may know us in your area as the PATH Project, the PEN Project, and the TEAM Project. And we are federally funded from a grant from Department of Education, Office of Special Education Programs, known as OSEP. We provide training and education, information, referrals, technical assistance, and emotional support for parents of children with disabilities birth to 26 years. So that is who we are. Before I introduce Ms. Colleen, I do want to talk about a few things over housekeeping, I guess, as far as Zoom goes. So you see that we have a chat box, and you're welcome to, enter in any comments, or if you're having IT issues, anything like that, go ahead and place those in the chat box. And we'll also share our links to our website and our Facebook periodically and throughout the presentation. And then we also have on your menu bar, and it may be at the top or the bottom, we have a little box with a Q, and then under it says Q&A. We are doing a live Q&A session after Colleen is done with the presentation, and we would love to get all of your questions. But I do ask that you put those in the Q&A box specifically. We have a lot going on in our chat box, and so we don't want to miss any questions, and the Q&A box is specifically for questions. So if you can just make sure that your comments, your IT, anything like that goes over in our chat box, and the questions for Colleen go in that Q&A box, that will be wonderful. All right, so today's speaker is Ms. Colleen Elbe. She is a supervising attorney with Disability Rights Texas in Lubbock. Colleen graduated with a bachelor's degree in psychology from the University of New Mexico and a master's degree in marriage and family therapy from Friends University. Prior to law school, she worked for a state family preservation contractor, providing therapy to families at risk of losing their children to the foster care system. Colleen is a graduate of Texas Tech School of Law, where she was a Board of Barristers member and graduated with a health law certificate. After graduation from law school, Colleen received a fellowship from Equal Justice Works to represent students with disabilities facing illegal suspension or expulsion. So thank you so much for being here, Colleen. I'm going to hand it over to you for the time being.
Okay, thank you. It's always so awkward to hear somebody else talk about you, but I appreciate that introduction, Megan. Like Megan said, I'll be answering some questions after I'm done with the presentation, but I do want to just remind everybody that it's not to be taken as specific legal advice. I like to think I'm good at what I do, but I'm not good enough to give you specific legal advice when I don't know backgrounds about your individual situation. So if you do have questions or want further involvement from Disability Rights Texas after today, I certainly encourage you to do an intake, and I'll be providing that information afterwards if that's something you'd like to do. So in talking about the options after high school for kiddos with disabilities, and I'm going to say kiddos all day long, but basically by this time we're talking about young adults that have disabilities, it shouldn't be any different really than the conversations you've been having since your child's been in kindergarten. When we talk about what's available for students with disabilities after high school, it should be completely individualized. So my goal here today is to give you a couple of different options, knowing that you have the availability of all these different choices to make a decision with your family about what's best for your particular student and your particular family situation. I think one thing we probably all have in common today is that all of you logged on today because you love somebody that has a disability, and because you want to see them succeed after high school. That's a scary time for parents. That's an exciting time for parents. And hopefully I can give you some information that'll ease some fears and make that transition a little bit easier when we're talking about kids moving to adulthood. So let's talk a little bit about being an adult. It's not easy. There are days where I certainly wish I could go back to graham crackers and milk for snacks and taking a nap every day. And there are times where the responsibilities of being an adult get overwhelming, and I look for somebody else who can help me make decisions in my adulthood. And that's really, that's the same thing as a student with a disability will have as they're transitioning from 16 to 17 to 18 to 19, and certainly something that parents have to consider. So when we think about what it means to be an adult, a big part of being an adult is what we call self-autonomy. And when we look to define that word, it basically means how a rational individual can make decisions for themselves. And when we think about what that looks like in adulthood, think about this morning. When I look at my morning this morning, I had to decide what time to set my alarm, if I was going to use the snooze button. I'm not typically a snooze button person, because if I hit the snooze once, it usually happens 3 or 4 times, but that's my personal choice. Had to decide how long it was going to take me to get to work, which way I should go, listening if there were any accidents or traffic, which in Lubbock is not too bad usually. I had to decide what to eat for breakfast, had to decide what clothes to wear, had to look at the weather to see if I needed a jacket. It's supposed to rain here today. So all of these things, I'm making decisions for myself, and I haven't even left the house yet. So when we talk about self-autonomy, as we move through the presentation today, because there's going to be differing options that affect self-autonomy at different levels, we really want to try to preserve that for people with disabilities. We really want to make sure that they can make the most decisions for themselves that are healthy, that are informed, and that are good decisions for themselves and for their lives. So that's just something to keep in the back of your head as we kind of go through today. Another couple of things that I think are important to remember anytime we're talking about individuals with disabilities. Luckily, the Texas law does presume that all adults, even adults with disabilities, have the capacity for decision making. That applies to every Texan, and so that's a good place to start from. It's good that that's in our statute, and that's a good mind frame for us to start today's conversation off thinking about. Also, another thing to remember is that decision making, it's learned. We don't come into this world knowing how to make decisions for ourselves or how to make decisions on behalf of others. And all kids, including students with disabilities, they need the opportunity to practice how to make decisions, to practice how to think through options, and then to follow through with whatever consequences, good or bad, come with their decision making. Another thing to remember is that, and we'll kind of talk about this in a second, but I think parents a lot of times think that guardianship is the only option for them to stay involved in their kids' lives once they turn 18, and that's simply not true. There are other legal ways to help people that you love and care about that have disabilities make good decisions for themselves. And again, those are going to be some of the options that we go over today. So just a couple things to remember as we kind of proceed. So not necessarily a quiz, but I want you guys to think back to when you were 18, 19, 20, 21 years old. I know, this isn't the format that I'd like to have where we can share kind of stories, but I'll go ahead and share a story with you. I made mistakes. I made bad choices. I dated a guy named James Cook. Bad choice. My dad told me he was a bad choice. My mom told me he was a bad choice. Some of my friends even told me. I didn't listen. I still made the choice to see this boy named James Cook. I don't know what he's doing today. I hope he's well. Didn't work out. I also, in college, decided it was a fantastic idea to spend $700 on a car stereo. Not a good choice. And so I want you to think about back to when you were a young adult. Did you have a James Cook in your life that you now looking back was like, oh my goodness, that's a terrible decision that I made? Or did you waste money on something? But those are two examples of a decision I made for myself and a decision I made for my finances that were not wise, but I didn't have that right taken away from me because I made a mistake. And so when I think about, students with disabilities, I think it's very, very important to remember that all people with disabilities have the right, just like I do, to make mistakes. And when we're talking about guardianship, we're talking about taking away somebody's rights to make decisions, good and bad. But sometimes bad decisions can lead to good results. I'm just fine personally and financially now, even though of those two examples that I gave you. And I think this is something very, very important that a lot of people either take for granted or don't understand, that people with disabilities have the right to make mistakes. I can't imagine if after I made those two mistakes in my life, if my parents or if a court system would have stepped in and said, you know what, Colleen, because you chose James Cook or because you chose to waste $700 on a car stereo, we're going to take away your decisions to make your rights to make decisions about yourself and about your finances. And that's really what a full guardianship does for people with disabilities. And again, I kind of challenge you. I hear people say, well, my student with a disability, doesn't know to read everything before they sign. I mean, really? Do you? When was the last time you downloaded an app, let's say on your phone, and read through all of the disclosures? I don't do that. I know when I go to CVS and I get a prescription, it comes with, I think, probably 7-point font of all of the different side effects of that particular medication. I don't read it. I trust other people to help me make the decision, like my doctor, on what medication to take. But just remember that just because you're afraid somebody can't make a 110% informed decision about things, we kind of do that every day. And it doesn't mean that we have any less right to make those decisions. So just kind of something to keep in mind. But I do know that there are a lot of families that seek guardianship simply because their child is turning 18. We see a lot of foster care situations where a child goes from a foster care placement as a child and moves into a foster care situation as an adult. Residential placement issues come up as well, in addition to, just private families wanting guardianship of their child. Sometimes you might be told as a parent at a school, at an art committee meeting, that that's your only option, that rights transfer to your kiddo when they turn 18, and if you still want to participate, that you have to get a guardianship. And that's simply not true, and we'll talk about that a little today. Sometimes that information could come from a physician that's encouraging a family to seek guardianship of a child. And sometimes parents just think that that's what they have to do in order to stay involved in their kids' lives, or to help them handle their money, to get them hooked up with the different community services, or that it's simply just the only legal solution. And again, what works for one family is not going to work for every family. So we're going to give options about how those legal solutions can look different for every single family. We'll start with guardianship, just because this is on the handout that TEA provides. It's called a model form that TEA provides to schools about options. Guardianship is first. I certainly wish it was last, and we'll talk a little bit about why in a second, but I kind of want to track that form, because more than likely when you get a model form in your transition ARDS, when your kiddo starts becoming 16, 17 years old, guardianship will be the first option that's presented to you. Basically in Texas, guardianship, it is a legal process to determine if somebody is incapacitated under the law. And there are two different types of guardianships, but both are decided by a court. Guardianships can be issued for physical or mental disabilities, but there's not one particular IQ cutoff or one particular disability where anybody that has that is eligible or anybody that doesn't is not. It's not like that. It's a completely individualized process done on an individual basis. But basically, a court's deciding if a person can manage their financial affairs, care for themselves, and be able to provide, the necessary food, clothing, and shelter for living a normal, healthy life. If somebody is under a guardianship, that means that somebody else is appointed to make decisions for them. So basically, it's removing the right to make decisions from that individual with a disability and assigning those rights then to somebody else. In Texas, we have two different kinds of guardianships. We have guardianship of the person, and we have guardianship of the estate. Somebody can have two guardianships over them, meaning there's somebody managing their person and somebody managing their estate. You can have both. You can have one or the other. You can have one guardian that does both to one individual, or you can have two different guardians for one individual. So one person might have a guardian that manages the person, and one person might have a different guardian that manages their financial affairs or their estate. So just like on what the slide says, a guardian of the person is responsible basically for any decision making that has to deal with the care of the person, where that person lives, the health care issues, who that person can marry sometimes, can that person vote, can that person drive, all of those decisions that a typical adult would make, those can be assigned to a guardian. And then both guardianships in the state of Texas, both of the person and of the estate, each of those can be full or they can be limited, meaning that a person can be assigned a guardian of the estate and they have complete financial control over everything that has to do with money with that person. Or it could be a limited guardianship of the estate, meaning that there are only some parts of the person's financial affairs that the guardianship manages, and the person with the disability retains rights to manage other parts. And again, that's done on an individualized basis through the court system. So again, guardianship does remove the person's freedom of choice and assigns those rights to somebody else. It does require a court order. It's a formalized process. This isn't something that families can just agree to do informally, and we'll talk a little bit more about that. It can be expensive. There are upfront attorney's fees for an attorney to file the appropriate paperwork in court. Sometimes those filing fees are waived, but a lot of times those attorney's fees are not, and they can be pretty hefty. There could also be a bond, a monetary bond issued by the court, meaning the court is asking the person who's applying for guardianship to kind of prove to the court that this is really what they want to do, and you put up money to kind of show the court that you can be taken at your word that you'll serve in this role as a guardian. Once you get guardianship, they can continue to be costly, because if you want to change that guardianship, what we call modify that, or if you want to terminate the guardianship, meaning you feel that the young adult has regained capacity, that all requires court involvement. So that all requires you have to file court papers, you have to show up at a hearing, you have to get doctor's notes. So it's a whole process once you get involved in the formalized system. If you want to get out or change it, it's still all very formal. And then additionally, one other thing that will keep a guardian in court sometimes, and it could cost money, it could be costly because you might need to incur services from an accounting person, is that you have to report to the court every year about the condition of the ward. So you have to submit these reports to the judge or to the court every year. And if you have a guardianship of the estate, you've got to show what money's coming in, what money you've spent on what, and what money is left over. And so a lot of people, once they think they have guardianship, that they're good to go forever, and that's just not the case. There's continual updates that are required to the court. Just something to kind of keep in the back of your mind. And, we talk a lot about what guardianship does with the assignment of rights and all of those things. But it's important to know what guardianships don't do. When I talk to families and parents of kids that are, turning 18 soon, the main reason they seek guardianship is because they say, I want to keep my kids safe. I want to be sure that they're not taken advantage of. I want to be sure that they make good decisions and that they're successful and healthy and happy in life. And really, that's not a guarantee with guardianship. We hear stories from all across the country that there are people who are exploited, even if they do have guardianships. So I just want families to know that just because you pursue a guardianship over a child that you love, it does not guarantee safety. It doesn't mean an absolute protection blanket over them from all of what might face them in the world. It just doesn't work like that. And there's certainly data that shows people who are under guardianships, they actually do not experience the same level of happiness and involvement in their day-to-day life, in their communities. Again, that self-autonomy it is just not there in individuals with disabilities that are under a guardianship. Typically, they're healthier, both physically and mentally, if they're able to make decisions for themselves. They have better jobs, they're better connected to the community. And so we really want to make sure we think about those kinds of things before we encourage families, oh, sure, just go ahead and get a guardianship. There's just a lot of different things that we need to remember that guardianships cannot do. So again, this slide kind of reminds me that guardianship is a legal process, and if you're a family that just doesn't like people in your business or in your life, guardianship might not be for you. What this slide tells us is that, when somebody seeks a guardianship over somebody, you're going to have an attorney involved. You're going to be the applicant, and you're going to hire an attorney to file that court paperwork for you. You're also going to need to hire a physician to complete a certificate of medical examination, or what we call a CME. So now you've got a doctor asking your kiddo questions about what they want for their lives, what they're capable of doing, what they struggle in doing themselves, what they need help with. That physician then will write that evaluation or that medical examination and submit that to the court. So now the court's looking at that as well. The person who is going to be the ward of a guardianship, the proposed ward, so the individual with the disability, once this gets to court, they're going to be assigned an attorney ad litem. The attorney ad litem's job is to basically tell the judge or tell the court whatever that person with the disability wants. Doesn't matter if they say they want to go on tour with Motley Crue. I don't even know if Motley Crue is still touring, but whatever. They want to go on tour with a rock band and tour the world, and everybody else in the world knows that that's not a good decision for this kid. If that's what that kid wants, that's what the attorney ad litem has to report to the court. They're simply standing in the shoes of a person with a disability before the judge. However, in the next column, it says that a guardian ad litem could be appointed. That's somebody that we're more used to hearing about. That's somebody that will come in and talk with the child, talk with the family, talk with anybody else that has good input, and make a recommendation to the court about what's best for that child. So again, even if the 17-year-old says, hey, when I turn 18, I'm going to get on a tour bus and, tour the world with a rock band, the guardian ad litem would be like, Your Honor, that's not what's best for this kid. Here's what this kiddo needs. So two different people, in addition to the physician and in addition to the attorney originally filing the application for guardianship, they get involved. Obviously, there's a judge involved because that's who's going to be making these decisions about whether or not the person qualifies for a guardianship, what kind, should it be limited, should it be a full guardian, and then also the judge is going to take into consideration who the person wants as a guardian. The judge has the right to decide, you know what, Mom, I know that you filed the petition for guardianship, but this kid says he wants his dad as his guardian. Eek, that could cause some interesting Thanksgiving dinners maybe, but it is up to the judge's discretion and has to take into account who the proposed ward wants as their guardian. But then also you might, as you're filing those annual reports that we talked about, you might have a court investigator that comes out once a year, every other year, to kind of check in, see how the ward is doing, see how the guardianship is progressing. Is it working for everyone? Is it not working for everyone? So that's kind of the guardianship process in a nutshell, and kind of everybody who would be involved. There are other people that might be involved, but that's kind of the standard basic cast of characters, if you will. Okay, so that's guardianship. And now when we kind of think about what other options there are for kids and families as these kids are becoming adults, there's definitely different levels of support and services and options to make sure that your kid is healthy and happy and ready to transition into independence with whatever level is best for them eventually. And some kids, unfortunately, the level of independence is in a parent's house, and that's okay. That might work for some parents, but I think a lot of parents are kind of like this cartoon, let's get you out of the basement. Let's get you off my couch and doing things more independently. So one of the options that we talk about typically is the change in the law that occurred a couple of years ago. I am a huge Days of Our Lives fan. So on this slide, I posted an old school picture of Bo and Hope, complete with his mullet and mock turtleneck, and then a more recent picture of Bo and Hope, characters on Days of Our Lives. Bo is now deceased. I'm sorry to report in case you haven't been keeping up with Days of Our Lives, but these are some of my favorite characters, and how they've changed over time makes me think about how guardianship in the state of Texas has changed over time. Weird connection, I know, but bear with me. Back in the day when Bo had his mullet and his mock turtleneck, the court could consider alternatives. It was very different from judge to judge. There were some courts that were very good at considering alternatives, and there were other courts that were known to not even give it a second thought. If somebody applied for a guardianship, they got it. So it just varied from state to state. Most consistently, it was all or nothing. So even though limited guardianships were an option back in the day, they weren't frequently taken. A lot of times courts, they figured if you need a guardianship, you need a guardianship, and it's all or nothing. Well, now kind of switching over to the new and improved Bo and Hope, just like the new and improved state of guardianship in Texas, every court in our state has to consider alternatives to guardianship prior to issuing a full-blown or limited guardianship of the person or guardianship of the estate. And that is now in our statute as a requirement to every judge considering guardianship. So again, a couple of years ago, most recently, I guess it was 2 legislative sessions ago, we were the first state in the nation to actually put in our statute that one of the alternatives to guardianship is supported decision-making. And we're going to talk about that in a second, but super excited that we were the first to have that codified in our statute. Texas isn't the first in many things, but that's definitely something that we're kind of, trailblazers about. So super proud about that. And we'll talk about that in a second. But again, when we talk about what else is out there, we're going to talk about some different alternatives to guardianship. And these can all be found in the statute. We have, Disability Rights Texas has a great booklet that's on our website. It's called The Right to Make Decisions. And you can download, you can print, you can browse that online. But part of that guide or that booklet on page 7 talks about all of these alternatives to guardianship. So I'm not going to go through and give really specific definitions of each of these because, again, a family might think they need a medical power of attorney, but not a rep payee, or vice versa. So you all have the opportunity to learn more about each of these on our website and pick and choose what works for you. But know that all of these are options provided to every single family that you do not need court involvement to access. Most of these can be done by a simple form and by a notary. So everybody agreeing to the form, and then a notary certifying that everybody's who they say they are and they know what they're agreeing to. There's benefits and drawbacks of each of these. For example, special needs trusts, those are very complex. You're talking about IRS laws, federal laws, state laws. I don't know too much about those. I certainly encourage anybody that's considering special needs trust to find an attorney that specifically practices in that area, just because they are so complex. But most of the other things are very workable. They're very user-friendly. They're simply forms that you have a conversation about. Some families might have done these exact same forms with their parents. Very similar, very user-friendly, and very flexible. For example, a durable power of attorney, you can make that for anything and everything. You could make that take place, in spring into action now. You could have that postponed until you're incapacitated, but you could complete that when you have your full faculties about you. Rep payee is usually used for Social Security payments or any kind of disability income that's coming in. One thing that I think a lot of people don't utilize as much as they should are just real simple bank accounts. A lot of banks, you can require like a secondary signature on anything over a specific amount. So you could do a pre-limited or a preloaded debit card. Lots of different banking options if you want to not have full control over a person's finances, but still be involved enough that you kind of make those limits so that they don't spend $700 on a car stereo when they probably shouldn't. But the last one on that list is supported decision making. And because it's so new, we're going to spend a lot of time today talking about that, just because it's something that, again, we're the first to do. Not a lot of people know about it. And it's just a fantastic option for so many families. So the underlying principles behind supported decision making. I just had a birthday, so I'm not going to tell you all how old I am, but I'm old enough that you would think I can make all these decisions on my own. I'm a fairly well-educated person, but if my brakes squeak, I still call my dad. And I still say, Dad, what do I do? Is this important? What does this mean? Are they going to go out? If I have bad news from a doctor and I don't understand all the words that they're talking about, I call my aunt because she's a nurse. And I might write down a word and I ask her, what does this mean? What did they tell me? Is this good? Is this bad? What should I do? I was given these options from the doctor. We don't make decisions in a bubble. We don't make all these life decisions by ourselves. If you think about a time where you were offered a promotion, but it was going to require more travel in your job, that's something you talk to with a spouse. How are we going to manage the day-to-day affairs of the kids if I'm gone more? You don't make those decisions by yourself. You're always talking to somebody else. You're always, asking other people, what do you think? Talk to me about, the recommendations you have for me. We bounce ideas off of the people that we love. And that basically is supported decision making. It's just telling a person with a disability, hey, you don't have to make these decisions alone. Here is a supporter that we'll talk about in a second that is there to help walk you through those decisions. And some of the best families for this alternative to guardianship, I always think of this kiddo that I work with who's placed at a state supported living center. And when we do his ARD meetings at the school district, if his grandmother is not there, he's 16 now, he might be 17, but I think he's still 16. If his grandmother is not there and they try to start the meeting without her, he lets the whole entire ARD committee know, no, we can't start without my grandma. That is a perfect family for a supported decision-making agreement, because that kid's already doing it. He's already waiting for his grandma to give her input before he makes decisions. And again, that's exactly what a supported decision-making agreement would kind of solidify and formalize for a family. But basically, just like with special education, there's no one particular size fits all when we're talking about supported decision-making agreements. But it's basically a person with a disability who's getting help from somebody they trust, somebody they choose in making decisions for themselves. So the supporter is not making decisions for the person, they're making decisions with the person. And that's a huge difference when we talk about having the right to make decisions for yourself versus having somebody else make those decisions for you. We know that people with disabilities have the right to make bad decisions, but we want to help them make good decisions. Again, we want to keep them away from the $700 car stereo. Okay, so let's kind of talk a little bit about where in Texas law you can find all of this information. Supported decision-making agreements, they are listed in the Texas Estates Code as an alternative to guardianship. Again, it's codified, it's in the law, approved by the legislature, so it's not something that DRTX says is a great idea. This is something that the state of Texas has said could work for a lot of families. Who can enter a supported decision-making agreement? Again, it would be any individual 18 or over that has a physical or a mental impairment that substantially limits one or more major life activities. To me, this sounds a lot like 504 wording. So if your student with a disability receives 504 services at school, this kind of language might sound very familiar to you because that's how it's codified, but I bet the Texas legislature didn't come up with this completely on their own. So that's who can enter into a supported decision-making agreement. But because you have to be 18 doesn't mean that these conversations can't start earlier. In fact, we encourage 16, 17-year-olds to be having conversations with parents and other loved ones about what's going to happen when they turn 18. And if this is an option for your family, we certainly suggest that you get out one of these forms, take a look at it, talk about it, and know what you're going to prepare once the child does turn 18. There is a very, very basic level of capacity. I talked earlier that, when you download an app or you read your prescription side effect warnings, we don't really read through all of those and understand all of those. It's the same thing with a supported decision-making agreement. Does the person have to know what every single word on the document means and all the alternative definitions? No. Do they need to understand that they're entering into an agreement where they still get to make decisions, but that they're going to get some help from their family or from their loved ones? Yes, that's the very basic level of understanding that's needed for a person to enter into this agreement. So very kind of floor basic, not a high level of education or a high level of functioning required, just the basic concept of, I don't have to make these decisions alone. I'm still making them, but I have help. That's all that a person needs to understand to enter into one of these agreements. Some questions we get is, does it have to be the parent that can be the supporter in these agreements? And the answer is no. It does have to be an adult. And really, there's not too many restrictions on who can be the supporter. Of course, we want it to be somebody that the person with the disability knows and trusts and hopefully goes to for advice already or for support already, so that that doesn't change too much when they turn 18. So typically, we see that they are a parent, a family member, some type of relative, or even a friend sometimes, selected by a person with a disability. It's definitely voluntary. That's another question we get. Do we have to go to court? if we have a supported decision-making agreement? And the answer is no. It is formalized, but only through notary services, not through a court proceeding. Not a judge does not have to look at this or approve it. It's done within the family. So the person with a disability has to agree to it, and then so does the recommended supporter, the person who's going to be giving the person with the disability support to make these decisions. It is voluntary. It is, another question we sometimes get is, okay, well, why wouldn't we just do a power of attorney? Well, a power of attorney is one person transferring their rights to make decisions or to sign a paper, a document on their behalf. They're giving those rights away to somebody else. So they're appointing somebody else to do that for them. That is not what supported decision-making agreements are. They are an agreement of, I need help to make these decisions, and I want you to be my person that can help me make this decision for myself. So in supported decision-making agreements, the person with a disability is still making decisions for themselves. They just have the promise of this additional help. And when we think about, as parents of teenagers, we think about all the things we do for our kids in a day. Make them dinner, buy them clothes, help them with homework, help them pick what classes they want to take in high school, talk to them about what they're going to do after high school. And those are all things that a supporter in a supported decision-making agreement can do as well. They assist an adult with a disability in thinking about all of the consequences, good and bad, of their decision-making. That's something that we probably do with our kids every day, practically, whether it's formally or informally. Are you sure you want to wear a short sleeve shirt when it's going to be 32 degrees outside? Let's think about that real quick. You might want to bring a jacket. That's stuff we do with 5, 6, 7-year-olds, although sometimes I still do that with my 17-year-old, but you get where I'm going with that. A person who's a supporter can help an adult with a disability go through medical records, ask questions to doctors, make informed decisions about finances, have the conversation of, okay, you've got $300 left this month, but you still have these 2 bills to pay. We need to prioritize this, and this is why. Again, teaching the person how to make these decisions and walking them through that, not making it for them. And then certainly helping them communicate their decisions to the right people. So if they're given an option at a doctor's appointment and they go home and think about it, a supporter can help them make the phone call the next day. Okay, I decided I want to do this, and can, tell them who to call or who to tell that decision to. Another big question that comes up from parents, especially of kids with disabilities, because they're so used to signing releases and signing ARD documents. So in addition to a supported decision-making agreement, an adult with a disability in school, so an 18-year-old kid, can sign a release of information to allow a parent to participate in an ARD meeting. So if a school tells you you can't come to an ARD meeting once your kid turns 18, that is not true. All a kid with a disability has to say is, I want my mom here, and they have to invite you. So that's just something to remember. As a supporter, you can access medical records under HIPAA. You can access education records through FERPA. There might be some additional releases that the person with a disability would have to sign. But again, a supporter cannot re-release those. They're kept in confidence because the idea is that you're using those to help the person with a disability make decisions. And then, again, it's kept privilege. It's kept, I hate to keep saying within the family, because I know that a supporter could be somebody outside of the family, but it's kept very confidential and very private. But you could have access to those. And in that same guide that I talked about earlier that's on our website, We do have an example of a release of information on page 12 of that guide, so that you kind of can talk about with your kiddo, here's the kind of release that you would need to sign in order for me to help you with this, or to look at your records, or to go over this with you. So the good thing about supported decision-making agreements is they can end when you guys decide you want them to end. It's not like guardianship, where you have to go back to court, you have to find another doctor to examine the person with a disability to say that they've regained capacity. It can be terminated by the adult with a disability. It could be terminated by the supporter. It could be a time-limited thing where within the agreement it says that the agreement's only good for 5 years, and then it ends at the end of the 5 years. Obviously, we're not going to let somebody who's a supporter that has allegations or substantiations of abuse or neglect of a person with a disability continue to serve as a supporter. So if there are problems in that area, then that's definitely something that could terminate a supported decision-making agreement. And that's just obvious, because we don't want those kinds of people helping a person make decisions with or without a disability. So that's just something to keep in mind too. Another question I get is there a form? Can I take a look at what's required, how it's worded? And the answer is yes. There's actually a couple different options as far as where to find a form. Sometimes it's difficult to find things online in our statute in the state of Texas, but there is a form in the Texas Estates Code, and I gave you the citation right there. Chances are if you Google that citation, the form will come up and you can print that out. But again, we do have a very user-friendly supported decision-making agreement example on our website. And that's in that document, that booklet that's called the My Right to Make a Decision. And then another option for a form is that a lot of times schools, when you have that transition ARD meeting, when, the 1 year before the student turns 18, TEA on their website does have a model form. And this is the first kind of paragraph of that model form that you can find on TEA's website. But if you scroll down, I think it's on the last couple of pages of the model form, you'll have a supported decision-making agreement example. So lots of different ways to find the form, to print it out, to go over, to talk about it, and to just kind of get used to what it looks like. So when we talk about what happens after graduation, what kind of options there are, if you think that supported decision-making is something that would work for you and your family, or any of these different alternatives to guardianship, or even a guardianship, it doesn't relieve the responsibility of schools to teach some of the skills that would help a person with a disability make good decisions after they turn 18. For example, Texas law says that adults have the right to self-determination in their finances. Well, kind of a matching transition goal that the schools could be working with a student on is how to open a bank account. I don't know if people balance checkbooks anymore, but maybe teaching a student how to use a debit card, what that means. It's a very abstract concept when you think about it. How to formulate a budget, how to stick to a budget, which is more important than coming up with a budget, I suppose. And a lot of things we take for granted. We take it for granted, the right to vote, the right to marry. Schools can teach a kid how to vote. I know here in Lubbock County, our elections office is fantastic. And if a school campus calls the elections office and says, hey, I've got a group of kids that want to know how to vote, they'll bring a voting machine out to the campus and let the kids practice voting so that they know what that looks like when they go to the polls. Not anything you'd ever think about, but that's an option for schools to be working with kids on. Again, a personal decision for families. Driver's licenses are usually a touchy topic for some families, but schools can help. Even if there's not a formalized course, they can work on a transition goal to get a state ID, or they can work on a transition goal to go through the driving test booklet, all the different rules of the road kind of thing. And then certainly a right for every Texan is to receive timely and appropriate health care and treatment. But that right comes along with a lot of needed practice. It takes practice to know when I call a doctor, what doctor I call, what do I ask for when I call the office. Those are all kinds of things that schools can be practicing with students, especially in those transition years, so that they can do that on their own once they turn 18, or with a supporter if that's something that your family chooses. So just kind of forget about all the words on the screen. I know it's very overwhelming when you first look at it, but basically what this is transition planning for public education. So this is just one section of all of the different requirements that schools have when they talk about what they need to do to get a kid ready for post-secondary school. So that could be anything from, of course, scheduling, courses, the instruction issue, the related services. Community experiences is something that a lot of schools kind of forget about. So if you want your child to have a particular community experience, that could be an option for you in transition planning through the school, again, so that your child can start practicing how to use the bus, if that's a skill that they're going to need after high school, how to use Uber, maybe if that's more, in Lubbock, Uber's kind of hit and miss. So, but I know in bigger areas, that's something that kids are much more comfortable doing rather than riding public transportation. Again, that's a skill that school can be teaching and giving kids the opportunity to practice using that app. And then, of course, this is kind of new. And again, I don't know how well schools are doing this. My guess is probably not very well. Recently, our legislature said that schools, in addition to all of that other stuff we just talked about with transition services, they also need to know and provide the options for parents to place their students on waiver wait lists. So I did this training for special education staff up at the service center in Amarillo, and I heard that we're talking about waiver waiting lists like 9, 11, 13 years long. So now, this is kind of the legislature saying school districts have the responsibility to talk to parents about their options. Again, I don't know how many schools are well versed on this because it is a very specialized area of services, but we, in that guide on our website that I talked to you about, in section 11, it talks about some of the community health and home service options. So it talks about some of those waiver programs, talks about some of the independent living programs that are available to students in Texas, and how to call and who to call to get more information on those. But if your school is not having these conversations with you, start asking questions about what living opportunities are options for your kid after high school, and hopefully they'll be able to get you the information. And I say that because I'm a big believer that we don't have to go through life alone. We're not created to be independent and do everything alone. We have to ask for help when we need it. My grandparents were Irish immigrants, and I remember my grandfather always telling me that everybody on this planet knew something that he didn't, and he thought that that was so exciting to know. And I really encourage everybody, a parent, a supporter, a student with a disability, when you need help, just ask for it. There's so many great resources and supports out there. If we work more together, we can definitely get more accomplished than if we go through this life alone. And then last slide, I gave you my personal, my work email, and then also the website to Disability Rights Texas, where you can find that guide that I talked about that has the model forms for community, for supported decision-making agreements. It has the list of community living options and waiver programs, and then it also has a much better description of all of the different alternatives to guardianships that we just didn't have time to get to specifically today. Again, if you have any questions specifically towards your particular child or your particular options that we don't get to today, I encourage you to do an intake, and you can do an intake by calling us, or you can do an intake online, do an education intake and let them know your questions or concerns, what the school is not doing, what you wish the school would do more of or less of, and we'll see if it's something that we can help with. So I'm sure we have questions in the chat box.
Yes, we do. Let me get Megan unmuted.
There we go. Thank you, Colleen. We do
You're welcome.
have so many questions.
Okay.
We will try to get through them best we can, and of course, see what we can do and try to get through as many as we can in the time we have.
Okay.
So, first question, please compare the pros and cons of supported decision-making versus the power of attorney.
Okay, so we kind of talked about that. Again, the biggest difference is that a power of attorney gives somebody else the right to make decisions for a person, whereas a supported decision-making agreement just is an agreement that they're going to get help to make those decisions for themselves.
Okay. Now we have a follow-up on the power of attorney. When do I need the general power of attorney versus the special or limited power of attorney?
So power of attorneys can be done whenever. They can be done the day your child turns 18 and you all agree to that. It could be when a person, like again, a lot of people use it with elderly parents, so that there's not an age requirement or a time requirement. That's just completely up to the individual.
Okay. And then what if a child has multiple legal guardians? How does that work for power of attorney?
So a power of attorney is separate than a guardianship. If you have multiple guardians, you probably don't need a power of attorney. But if you're talking about two parents of a child or two custodial individuals of a child, maybe grandparents or something, then they can enter into a power of attorney with one. They could assign those responsibilities to two different people, some to one person, some to another. Power of attorneys, durable power of attorneys are very flexible.
Okay, perfect. All right, next question/comment. I'm looking forward to the presentation. So they were excited. Interested in what all are alternatives for getting funding for low-income families for guardianship. What alternatives are there for families to have medical power of attorney when the client is not competent to sign the forms?
Okay, so two different questions. Let's talk about the first one. Unfortunately, there are not a lot of financial options for assistance in getting guardianships. A lot of places won't charge filing fees. They'll waive the court fees and the filing fees, but the attorney's fees those are always the most costly for families. And there's just not a good across the board option as far as what's out there to help low income families in guardianship. Now, again, remember, a lot of the alternatives are free and they don't require any kind of court filing. You just need a notary service. A lot of times that's free at banks if you have an account with a bank. So just kind of keep that in mind. And then the other one was if somebody's not competent to sign, was it a medical power of attorney?
Yes, the medical power of attorney.
Okay, so the legal competency level to sign the power of attorneys is very low. So I would need more information about what makes the person not capable of signing. If they're in a lot of times medical power of attorneys, people start talking about those when there's end of life decisions. And so, of course, if a person's in a comatose state or not able to respond to anything, then that cannot be signed. But if a person can't, just because a person can't write or can't speak does not necessarily mean that they don't have capacity to enter into that kind of an agreement. So it just kind of depends. And I hate to give that answer. I'm sorry.
All right, so we have my 20-year-old son with autism and OCD just tested for STAR Care last week. If
Okay.
he's accepted under the ID side, can they require us to be guardians to him? They haven't said that, but she's wondering if they might.
Absolutely not. And if they say that you have to be, that's definitely a problem. Again, just because somebody recommends that or encourages that does not mean that that's something you have to do. They might require that if your child is 18 or over, that the child signs some type of release of information for you to be involved, but they cannot require you to be a guardian, no.
Okay. What is the name of the form that you're supposed to get during the transition process?
Okay, so from the schools, TEA has issued what they call a model form. So basically TEA announces to the districts, hey, here's what we think you should be providing to families. Districts will sometimes tweak that and not use it as exactly as it comes from TEA, but basically it's a handout about the transfer of rights when a child turns 18. You should be getting that 1 year before they turn 18, and that should come with a list of alternatives to guardianship, information about guardianship, and information about supported decision-making agreements.
Okay. We have been told that we have to pay for our student's attorney. Do you know anything on this?
For guardianship, possibly. So if the court appoints an attorney ad litem, there might be for your student, there might be some costs associated to that. You would have to pay for your own attorney to apply for guardianship, definitely. But there could be extra costs associated with some of the other players in the cast of characters, yes.
Okay. All right, I am the parent of twin 19-year-old boys with an autism spectrum disorder diagnosis. Their bad decisions involve potential involvement with the Texas criminal justice system.
Mm-hmm.
Judgment and decisions for them is the only thing standing between them and severe and possibly unjust treatment from law enforcement. We're lucky to live in Travis County, where the officers are better trained.
Okay.
So decision-making has not worked for us so far. Texas prisons are full of people with special needs and mental illnesses who really belong in hospitals and need medical care. So I think that's more just a comment. Our goal is merely to have a happy life, but to stay out of Department of Criminal Justice system.
And exactly like I said, every family is different, every situation is different. So what works for one family is not going to work for everybody. And luckily we have options.
Do families have to show that they've attempted multiple alternatives before filing for guardianship?
So yes and no, that's kind of a trick question. They have to talk about what they've considered, so that you don't have to necessarily go through a time period where you've tried being a rep payee and that didn't work and it failed. Nobody's going to set you up for failure, but there at least now has to be a discussion about what else has been considered prior to coming to court to get guardianship.
All right. Which website is the right to make decisions on?
That's on the Disability Rights Texas website, so www.drtx.org.
Okay, I'm going to go ahead and send that over in the chat box as well. What are the options for a nonverbal 18-year-old? The mother cannot afford to pay attorney fees.
So, a good question. Just because somebody's not verbal doesn't mean they don't communicate. Parents and loved ones are going to know that kiddo the best, and if that 18-year-old can express in some other way what they want or who they trust, that's definitely something that you can work with and look at all of those options for all of the different alternatives.
All right. Is guardianship the only option for a child who is severely mentally handicapped? He's 17, but doesn't talk. He isn't potty trained. He mentally is about a 2-year-old level.
Guardianship is never the only option for any person with a disability in Texas. It's going to be what works for you, your kid, and your family, but just know that everybody has options.
All right. I am an advocate in my profession, and I have a child with a disability. I advocate in over 14 counties, and all counties are different in how they handle guardianship. Why is that, and why is it not consistent throughout the state?
That is a fantastic question, and I really wish I had an answer to it. I don't know. But I do think we're getting better. Now that courts have to consider alternatives, I do think that hopefully in the next couple of years we'll see more consistency. But that's a great question that I just don't have an answer to.
All right. And this is another one of those where it's kind of more opinion. What's the best option for people with IDD? We have a family school. The school told them that they needed a guardianship since client will soon be 18 for academic and personal decisions.
So that's not true. Again, nobody absolutely across the board 110% has to have a guardianship. Kids that have, young adults that have intellectual disabilities, they're just like any other disability category. You can know two kids that are on the spectrum and they're completely different. If you know two kids that have intellectual disabilities, they might be completely different. It's about what works for them. If they have the basic capacity to understand that they're entering into an agreement that somebody's going to help them make decisions for themselves, they could do a supported decision-making agreement. They don't have to do guardianship.
All right. Do you happen to have any contacts in Arkansas that could help a parent who's looking to get some assistance to get tasks taken care of, such as paying property taxes and things like that?
I don't. If you're looking for assistance with like transition services at school or alternatives to guardianship, you might want to check with the Arkansas PNA. I don't know who the protection and advocacy system is in Arkansas, but every state has one. And if you're looking for an attorney in a very specific area, like property or special needs trusts or something, you could certainly contact the Arkansas Bar and request an attorney referral, and they should give you a list of people.
All right. Let's see. What happens if you have a supported decision-making agreement and the support person passes away?
Great question. So one of the ways that a supported decision-making agreement is flexible is that you could appoint a successor supporter, meaning that if something happens to the original supporter, that successor supporter just steps right in. Or you can create a whole new agreement with somebody else that person with a disability trusts and wants helping them make decisions.
All right. If a young adult, an 18-year-old, is incapable of comprehending or signing any of the alternative documents, is guardianship the only alternative for parents to sign medical treatments for their child?
Medical treatments. Medically speaking, I don't know, because I think a lot of providers would still talk to parents, even if the child was an adult. If they're nonverbal and non-communicative, then I think physicians and facilities would still, take a parent's wishes into play with medical decisions. But as far as having the right to make medical decisions, again, it depends. If I don't really understand, without knowing the adult student, how incapacitated they are, and how much they could understand about just helping make decisions versus making a decision for you. But a medical power of attorney might be something that they could look into, and again, there's forms for that online that they could take a look at.
Okay. Do school districts and physicians respect or have to allow the supported decision-making agreement? If not, what recourse does the adult have?
So in reality, the answer to that is yes, they have to respect and allow that. But in practice, I understand that this is a new concept and some people might not yet be well versed on what it means. The good news is that within the form agreement, there is specific instructions on what it covers and what it doesn't cover, but we still see a lot of times physicians requesting that one additional release of information about HIPAA, releasing, private health information under HIPAA. So there could be some explanation that has to go along with the agreement, but typically once that's explained, they should follow it. I think schools are going to be better than doctors, hopefully.
All right. Let's see. Trying to get some questions a little farther down. So give me just a second. Can an individual have more than one supporter in a supported decision-making agreement, such as both parents?
Yes, they can. And it could be both of those for all of the decisions. It could be maybe that a student feels more comfortable with mom for some things and dad with others, and they could have two different supported decision-making agreements. Again, completely flexible, whatever works for you in your particular situation.
All right. For medical power of attorney, does the 18-year-old still have to have some capacity to understand and sign?
Yes, because it's the 18-year-old giving someone else the right to make decisions for them in a power of attorney situation. So there does have to be some basic level of comprehension of what they're agreeing to, yes.
Okay. Can power of attorney be done by notary, or does it need to be with an attorney?
Power of attorney can be done just by notary. You do not need an attorney for that. And those samples of power of attorneys are online. You can Google that. You can go to the estates code and pull up all of those forms.
All right. With regards to correct decision on the guardianship of parents over the decision, okay, I think these came in opposite order. Who watches over the decision at the level of justice? Does Texas have a case review process on those types of sterilization issues? And it says with regards to correct decision on the guardianship of the parents over the decision.
I don't understand. Sterilization? That's not something we talked about. I don't understand the question, I guess.
Yeah, we'll see if they give us any further details.
Okay.
Sorry. A two-part question, so we'll see if anything else comes back up. All right. What happens when a dentist or doctor says a young adult needs a medical procedure and the young adult does not want it and you only have the supported decision making? Is it true that no medical care will be given until it becomes detrimental?
So it's true that if you just have a supported decision-making agreement, the person with a disability is still making decisions for themselves about their health care. So yes, that would be true that you are helping them talk about and think about those options, but they're the ones who are actually deciding whether or not to receive that procedure.
All right. Is there an end date for supported decision-making agreements?
So we talked about there's a couple different opportunities of when they can end. You can either put that in the agreement if it's a time limited thing for the next 1 year, 5 years, 10 years, whatever. It could be when the supporter passes away and you need a successor supporter. It could be when the person with a disability chooses to end it, and it can also be when the supporter chooses to end it. So a couple different ways it can end.
All right. I'm looking through. We only have enough time for maybe 2 more questions, so I am trying to choose one. I was told I could not do a power of attorney because son is incapacitated. Is this true?
I would want to know who told you that, because again, incapacity could mean a lot of different things, but a power of attorney, yes, there has to be some basic level of understanding that that person is giving away their rights to make those particular decisions to somebody else. So yes, there would have to be some level of understanding, but again, I'd want to know who told them that and if that person really does not have capacity.
All right. And can you give medical decision making or power of attorney for set dates? So, for example, if you're going out of the state or country and leaving your child with somebody.
Yes, yes, you can. Yep. If the child is under 18, you can do that as a parent. You can assign those rights to somebody else for a particular period of time. If the child is 18 or older, they have to consent to that because, again, they're giving their rights to make those decisions for themselves to somebody else. But that's definitely an option, yes.
All right. Let's see. One more question. Could you have a supported decision agreement and a power of attorney for certain areas like healthcare?
Yes, you certainly could. One is not exclusive of the other, yes.
All right. Well, I know that we didn't get through all the questions, but we tried. So if anybody has additional questions, we can certainly send these over to Colleen. You can definitely email me or Christina, and we can get you in touch with somebody who will be able to provide you with some kind of assistance. Sorry, we just had way too many questions to get it all done.
It's a really complicated topic, and I'm sorry. I tried the best I could to answer all these questions.
So, I'm sorry. I again apologize to our audience if we did not get to your question. Please, feel free to email those to me, and we'll get you in touch with somebody or get you an answer the best we can. And thank you guys for coming today, and thank you so much, Colleen, for jumping.
Sure, thank you.
We really appreciate it. We do have 2 more webinars coming up this month. So the next 2 Tuesdays, you can join us again. Next Tuesday, May 14th, we have Life After High School, and that's going to be with Araceli Olmeda. And she's going to talk about the transition out of high school and what options are available whenever you're looking at transition and workforce and things like that. And then on May 21st, we have our rescheduled ESY webinar with TEA. That's coming up here in 2 weeks. We're going to do 12:15 is going to be English, and then immediately following at 1:15, we're going to get on a webinar and do the Spanish version. So make plans to join us for both of those. This is our information, and we'll leave this up for just a minute. You can definitely email me or Christina with any questions or comments about the webinars. And then check out our website. This has all our recorded webinars on it, and it also has the handouts for the presentation. So if you're one of the many people who asked for a copy of the PowerPoint today, you can access that on our website. And I think I answered that for everybody who typed it in the Q&A box, but if I didn't, this is the website you can pull it from. And then we do share the recording on our Facebook, as well as do some really cool Facebook Lives and share some really cool things on there. So if you're a social media person, make sure you join us on Facebook. Thank you guys for coming. It's been a great presentation, and we hope that you guys got the information that you were looking for.
Thank you, Colleen, so much. We appreciate it.
Thank you.
You bet. Thank you, guys.